Hello, my name is Akshay Ganagunta. I'm currently a freshman at Greenup High School, but today I'm not a high schooler. I'm going to be your lawyer reacts. Today's discussion stems from life, pain, death, and suffering. The Epstein Files. In November of 2025, President Trump signed the Epstein Files Transparency Act into law, requiring that the Department of Justice to release every file related to convicted sex offender Jeffrey Epstein. What followed was one of the largest mass document disclosures in American legal history. Nearly 3.5 million pages, thousands of videos, and hundreds of thousands of images released to the public. But here's the problem. Survivors of one of the most horrific sex trafficking networks in modern history, women who were promised legal protection, had their names, home addresses, banking information, and in some cases, nude images published to the entire world. Not by a hacker, not by a leak, but by their own government. So today, I want to answer this question. When transparency becomes weaponized against the very victims it was meant to vindicate, what does the law require? What did it fail to do? And what systemic standards must we build to make sure this never happens again? Let's define the problem precisely, because this isn't just a story about bad redactions. This is a structural conflict between two legitimate and legally protected rights. On one side, the public's right to know. When powerful institutions, the FBI, federal prosecutors, and multiple administrations fail to hold elites accountable, transparency is the democratic remedy. The public has a constitutionally grounded interest in government accountability, and when there is credible evidence of a cover-up, disclosure must remain a priority. On the other side, we have survivor privacy. Victims of sex trafficking are among the most legally protected individuals in our system. Their identities are shielded by multiple federal boundaries, court orders, constitutional privacy rights. And many of these women never chose to be public figures. Many were minors when they were abused. Their safety, mental health, and in some cases, their literal lives depend on staying anonymous. Attorneys representing more than 200 alleged victims called the release the single most egregious violation of victim privacy in one day in United States history. And that is the collision I'm analyzing today. Transparency law versus victim protection law. And I'm going to argue that right now because we have neither one working properly. First, the Epstein Files Transparency Act itself. Signed by President Trump on November 19th, 2025, the act required the Attorney General to make all Epstein-related files publicly available in a searchable and downloadable format within 30 days. It also mandated an unredacted list of government officials and politically exposed persons to be sent to congressional judiciary committees. The act was bipartisan. 90% of Americans in a September 2025 Marxist poll supported releasing the files with the victims' names redacted. Transparency was the mandate and victim protection was the condition. Second, the existing legal protections of the DOJ was already bound by. The DOJ's own disclosure page acknowledged it was required to comply with the Crime Victims' Rights Act, 18 U.S.C. 3771, which guarantees victims the right to be treated with fairness and to be protected from the accused, 18 U.S.C. 3509, which protects the privacy of child victims in federal proceedings. Federal Rule of Civil Procedure 5.2, which mandates redaction in personal identifiers in court filings, and grand jury secrecy rules under Federal Rule of Criminal Procedure 6E. These were not optional. They were cited directly on the DOJ's own disclosure page as required protections. Third, what actually happened, and here is your real-life case. A Wall Street Journal review found that at least 43 victims' full names were exposed, including more than 24 who were minors when they were abused. Some names appeared over 100 times, and home addresses were visible in keyword searches. Faulty redaction techniques in this December 2025 release allowed members of the public to recover fully blacked out content by simply copying and pasting it into another application. This was not a sophisticated hack. Any ordinary person with a laptop could undo the government's redactions in seconds. Attorneys representing 300 survivors had provided the DOJ with a list of 350 victim names on December 4th, just a couple weeks before the release. Specifically so, those names could be verified as redacted. A simple keyword search of the database could have easily caught the errors, but it was never done. Now, a federal lawsuit filed in the Northern District of California alleges that the DOJ and Google exposed approximately 100 survivors, and that online platforms continue republishing the information even after victims requested takedowns. The complaint states that the DOJ prioritized rapid, large volume disclosure over protecting victims' privacy. One victim reported receiving death threats. Another had 51 file entries exposing her private banking information, forcing her to shut down accounts. One woman described the release as life-threatening. So where did policy fail? Let me break this down. The DOJ prioritized speed over safety. With 3.5 million pages, videos, and images to process under a 30-day congressional deadline, volume became the enemy of accuracy. Rather than request an extension, the DOJ raced to meet it. The law wasn't built for this. FOIA was designed for individual or small batch requests, not simultaneous mass disclosure. There is no statutory framework requiring validated redactions, pre-release audits, independent review of victim notification at this scale. The reactive model failed. The approach was release everything, wait for victims to flag errors, then remove files within 24 to 36 hours. But this model was applied to an irreversible harm, because once the name is published online, it cannot be unpublished. Even after the government acknowledged errors, platforms like Google continued republishing the material over and over again. The technology was inadequate. Basic pre-publication checks, copy-paste redaction testing, metadata review, and consistency validation were never performed. These were industry standard practices and they were skipped. What partially worked. Bipartisan support for the act, show transparency, and victim protection aren't inherently opposed. The DOJ did redact over 1,200 victim names. Deputy AG Blanche noted errors affected only 0.01% of materials. But even 0.01% of 3.5 million pages is still thousands of exposures. In matters of trafficking survivorship, even one exposure can be catastrophic. I want to pause here and talk about who bears the cost of this failure, because it's not distributed equally. Epstein's victims were disproportionately young women, many minors, many from vulnerable backgrounds, targeted because they lacked power. The justice system failed them for decades. Now, even in 2025 and in 2026, the transparency effort meant to vindicate them fails again. Powerful men stay redacted while survivors have their identities, addresses, and trauma exposed. This is what legal scholars call secondary victimization, institutions re-traumatizing survivors through their own processes, and it hits hardest with those with the fewest resources. A well-connected man has lawyers and media counsel. A low-income survivor exposed in dozens of documents has to shut down accounts and fear for her safety. Any policy that treats disclosure as purely procedural, ignoring the gap, misses the point. So what do we actually do? Here is my proposed framework, implementable, legally grounded standards, not vague aspirations. 1. Mandatory pre-release redaction audits. Amend FOIA to require independent audits before any mass disclosure over 10,000 documents. Copy-paste bypass testing, metadata scrubbing, keyword checks against victim name lists. This is already standard in litigation and document review. It should be required for government releases too. 2. Victim notification protocols. Before releasing documents in trafficking cases, the government must notify survivors through their counsel and certify all identifiers are removed. The DOJ had the victim name list in December. They just didn't search it. A protocol with judicial sign-off would have easily got that. 3. A special master. Survivors' attorney actually requested this. Courts already use special masters in complex litigation to provide independent oversight. For politically charged, high-volume disclosures where speed and politics pressure agencies to cut corners, you need a neutral third party with real authority. 4. Platform takedown liability. Once the government exposed those names, Google kept republishing them. Modeled on DMCA takedown procedures, Congress should create a fast, legal mechanism for victims to compel platforms to remove improperly disclosed personal information. Right now, that tool doesn't exist, but it needs to. These proposals are all feasible when existing constitutional frameworks, buildable on existing legal tools, and targeted at the precise failure points we identified. Now, let me bring this home. The Epstein Files case is not really about Jeffrey Epstein. It's about a question that will define how democratic institutions function in the age of mass information. Can we have accountability without cruelty? That answer has to be yes. Transparency is not an abstract ideal, it's how power is checked. But victim protection is not a bureaucratic inconvenience. It's a legal and moral obligation owed to people who have already been failed, repeatedly by the institutions that were supposed to protect them. The law already recognizes both rights. What it lacks is a real system to make sure that work at scale, pre-release audits, victim notification, and special masters and platform takedown rights are not radical ideas, but the minimum basic justice requires. Because transparency that harms the survivors it was meant to vindicate is not accountability. It's just another form of institutional violence wearing a different name. Thank you so much for your time, and I hope that you learned how our system failed as citizens and how they can launch us back. Thank you.